Welcome to the Trial Bible, where we break down the secrets of courtroom victories with the best trial attorneys across the country. Each episode will sit down to explore their recent winning verdicts, the key pattern jury instruction charge that made the difference, and the tools they use to hit big. Let's go. All right, welcome back to the Trial Bible, where we peel back the legal curtain, one verdict at a time. I'm your host, Gennady, and today we're riding into some seriously bumpy territory. Buckle your helmets, folks, because we're talking about a Harley Davidson Trike that went from freedom machine to legal nightmare. Joining me is one of the most incredible trial attorneys I know, who took this defective trike case all the way to the finish line and left the jury roaring louder than a V-twin. Please welcome the man who revved up the courtroom, Daniel A. Thomas. Daniel, how are you doing today?
I'm good, Gennady. How are you? Thanks for that intro. I can safely say that's never been introduced like that ever.
Pretty on point.
Very kind.
All right. So let's jump right into it. Give us the opening throttle here. What happened in this Harley Davidson Trike case? What are the details that you started off with in the beginning of this case?
Okay. The most important detail is that Harley Davidson decided, in order to keep its older, aging ridership, it was going to go forward with a trike, a three-wheel trike, which is essentially one wheel in the front, two in the back, and loaded up with all kinds of bells and whistles, including things that actually were counterintuitive to the actual safe operation of the machine, including a feature called traction control. So they put all these bells and whistles in terms of assist and warning signs, and lights would go on and all that stuff, but they didn't really think it out well, and they rushed the production. They had combined their resources and they retained the services of a Bosch engineering group to build some of the software features, including the traction control. You had a scenario in which the client, Harold, just he and his girlfriend, Pam, longtime Harley riders, she was getting a little skittish from having been on these two-wheelers, and as they're getting older with balance issues, so they decided they were going to trade in the two-wheeler for the three-wheeler and get this 2019 Harley Tri Glide trike. Bought it brand new, and ultimately things were going fine, but about 1,000 miles and change, about 1,050, 1,060 miles and change, they're in Florida with the trike, and the thing just suddenly veers off to the left, across two lanes of traffic over a grassy knoll, and then ultimately crashes into bushes. They get hurt, but not severely, and the bike gets pretty banged up, sends it back to where they came from in Rochester, New York, and had it repaired, and just didn't know what happened. He just couldn't figure it out. Then fast forward so that was February of 2019. Fast forward to November of 2019, Harley puts out a recall notice saying we have a defect on the bike, and bring it into your dealer and have a software patch put on. And Harold says, wow, that sounds like what happened to me. Contacts Harley. Harley's like, well, we looked into it, we investigated, and sorry, it's not the defect. You're going too fast. The defect only happens under 40.5 miles an hour. So too bad, so sad, sorry, can't help you. Go with your insurance. It's not a warranty issue. It's on you. Could be operator error, but don't look to us. So he sort of accepts that because it's all very formal. It gets a letter and a whole deal. And then fast forward to June of, actually today is the anniversary, the 5-year anniversary, June 6, 2020. They're in Pennsylvania, and the trike, again, after it was repaired and the software patch was put on it, suddenly goes off the road. And this time it goes up an embankment, and Pam was ejected, the passenger, and she sadly died as a result of being ejected in her injuries. And Harold was severely injured. He was in a coma, and they gave him last rites like 4 times in the first 2 weeks. And basically Harold's son reached out to a friend and connected with a lawyer named Paul Edelstein, who's also an excellent trial lawyer, and he asked me to come on board. And so the two of us took the case on together. He represented Harold, I represented Pam and the estate, and we started digging in. And when we started digging in, we found a lot of really, really shady stuff.
The fact pattern, as I understand, is you have two plaintiffs. We have Pam and Harold here, a couple who love riding the Harley. They get into an accident. They don't really understand how that accident occurs. And Harley tells them, don't worry, we fixed the bike. Your accident has nothing to do with the recall that we just sent out. You're safe to get back on the road. And then months later, they get into another accident and she tragically passes away. Is that right?
That's correct.
What is your thinking taking a case like this on in terms of challenges that you think you're about to face?
Well, one of the biggest challenges is you're going up against a behemoth corporation that, putting aside the money that's at issue there, you're going up against a company that has been down this road many times before. Harley's been around for years and they've dealt with all kinds of litigation. So they are well seasoned at litigation, defending their products, defending accidents, people getting injured, people getting killed. And I'm not. I'm a sort of just a scrapper, medical malpractice, personal injury attorney who is up for the challenge. And my attitude was bring it on. And I knew I was going to be up against big guns, but so what? I'm ready.
Let me ask you this question. You have to pick a superhero. Who are you in the courtroom? Which one?
Well, probably a hybrid. Superman and Spider-Man.
Well, I didn't expect you to say that. I could have swore that you were going to say Batman because I know you love the gadgets. You love the high-tech stuff. I see you as a Batman. Tell me why you're a little bit of both Spider-Man and Superman.
Well, Superman in my attitude, invincible. You got to be. You have to adopt that attitude. That's absolutely a necessity to go up against anybody, big or small. Spider-Man, because he's my favorite superhero. And his motto is, with great power comes great responsibility. And I've tried to live my life that way, both personally and professionally. So I couldn't possibly leave him out of the equation. So
just a boy from Queens trying to do right for the neighborhood.
Right. Just looking for that radioactive spider to bite me. And then I'm off to the races.
I love that. All right. So I think a big part of this case is what happened before you even stepped into the courtroom. Is that fair to say?
Sure. And I think that's actually appropriate to say about many cases, if not most cases. Preparation, I mean, you can't stress enough how important preparation is. The difference between a good lawyer and a great lawyer is one who knows his stuff cold and then does not forget who his audience is, his or her audience is. Because as well as you might know the minutiae and the detail, you're selling your case to people that haven't heard it before. You have to make it accessible. So the preparation comes in both understanding it and then being able to break it down so you can convey it simply.
So this case came to you. I mean, it must have been appealing that you have an accident and you have a trike and you have a recall on that trike in the months before the accident happened. So tell us a little bit about the discovery, about what Harley Davidson provides you in discovery, and what you did in order to get everything that you needed.
Well, like any case, you want as much information as you can. And in a product liability case like this, there's going to be a lot of paper. And we asked for all of it. Harley wanted to have all kinds of agreements regarding non-disclosure and confidentiality. And they're saying they weren't going to give us certain things because of proprietary information. They weren't going to risk it being out in the public domain. So a lot of hurdles, because they were actually controlling all of the material. They were controlling what they gave, when they gave it, how they gave it, what restrictions they placed on it. And you're sort of stuck, you're held hostage to what they want. And most courts are not going to have at their say-so, so Harley's say-sos, most courts are not going to force them to turn over stuff that are potentially trade secrets that can be out in the ether like that. So
did you make any motions for additional discovery in this case?
Of course, made lots and lots of motions and got lots of backlash, and ultimately got some. As we kept going, you'd get a little more and a little more, and there were little compromises made, and you swing deals, and eventually you piece together sort of a nice appendage of, assemblage rather of materials, which in our case totaled about 20,000 pages of documents.
You get 20,000 pages. Is that enough for you?
Well, it's all they were given. So it had to be enough, and we kept asking up until trial. basically saying we don't have this. Like, for example, insurance information. We didn't have insurance information. What we were told was Harley has enough to cover any judgment in the case. That's the most we were given. Hey, judge, they didn't give it. The CPLR says they got to turn it over 30 days. That was years ago. And like, well, yeah, we'll give it, but not yet. I mean, okay, there's bigger fish to fry. So that's an example of, you got to be on top of them. And if you can't force them, you can't force them. A judge could force them, but in this situation, we had different judges throughout the course of the case. So there wasn't enough continuity for one judge to really know the whole history, and everybody gives them a break. But be that as it may, yes, we did motions, but the biggest sort of breakthrough in the discovery process was as we were going through these 20,000 pages, and you have to go through it all. There's no way around it. You got to look at every page. Discovered that there was some pages where the writing was cut off, and having a little bit of a tech savvy understanding of the world, records come in different forms, and they gave us PDFs, which are pretty much static documents, PDFs of Excel spreadsheets. And these Excel spreadsheets are programs that have layers and layers, or like a book has many pages. These programs have pages of information behind. They're called sheets. You could have one sheet, you could have 50 sheets, and a PDF is only one singular document. So,
and it just shows that front sheet. It doesn't show you the sheets behind that same document.
That's right. And we did see, though, in the PDF that there was some writing that was cut off, because essentially it's like boxes and like a table, and some of the print went beyond the boxes or underneath and was cut off. So we had to get the raw data, and we did.
And what did you find out in the raw data that they provided you?
Well, upon getting the spreadsheets and looking through the various layers that were not initially provided, we learned that there were numerous instances of these complaints that did not match the public face that Harley was giving, of only 5 instances that resulted in a recall.
So I want to talk about the actual recall itself. Tell us what it is that Harley said, what the recall was for, and why it was published.
Okay. Harley basically put out a recall saying that there was a defect with their traction control system. It was a software defect, and that it would engage one rear brake intermittently out of the blue with no warning, causing the vehicle to change direction and making it more likely to have a crash. So that's essentially what they put out there as their recall. But they only represented it to be a software issue. A lot of people were going along, and this is, it's a dangerous thing, because you have 2 rear wheels. One is going to break. It's going to change completely the direction of the vehicle. And they said, bring it in and have it fixed, sort of like you have a recall, a software update on your computer, right? Security fix, a patch, things like that. So that's what they told. It was a worldwide recall. All the owners, all the dealers.
And that worldwide recall mentioned that there were only 5 instances, or through their own records, it showed that under the specific details of this recall, there were only 5 instances that applied to this recall?
Well, the company makes a decision that there's a defect sufficient enough to warrant a recall. They then contact the National Highway Transportation Safety Administration, NHTSA, and they work with the federal government by saying, hey, we need to recall our product. Here's the basis for it. Here's the reason. Here's what we're looking to do. And if you tell on yourself, so to speak, right, it's called a voluntary recall. Company goes to the government and says, look, we've discovered something. We want to fix it. Here's what we're going to do. The government usually says, okay, great, go for it. As opposed to a forced recall, where the government tells a company, we found a defect and we're going to basically oversee and supervise your remedial measures. So Harley has basically had numerous recalls over the course of its history, and it proudly stated in court, it never was forced to recall. It was always a voluntary recall. Now, they take that as a badge of honor, but in reality, they know that if they were forced to do a recall, that they were going to have way more restrictions on them and much more oversight. So they do a voluntary recall to reduce the amount of restrictions, reduce the amount of oversight, and give them a lot more freedom and flexibility, including plausible deniability. So the 5 instances that we're talking about were really the representations that Harley made to the federal government in connection with this recall, saying, hey, we've learned about 5 instances, we want to do the recall.
And after you uncovered those additional pages and layers and sheets of the Excel, how many actual instances or complaints dealing with this exact issue did you find?
Within the time parameters that we had, which was not the full chronology, there were 90 in about an 18-month period.
That's crazy.
Yeah.
90 instances of complaints that they conveniently said that's not related to the issue at hand here of why we voluntarily chose to send out this recall.
Right. They basically had two choices, actually three choices. They had a complaint, they had to dub it either relevant or not, an incident or not, and it had to be both relevant and an incident before it would be considered related to the recall. So they just simply put an N in the column as to whether or not it was relevant, or an N in the column whether or not it was an incident.
Let me refocus to Pam and Harold and their tragic incident.
Okay.
We have one plaintiff has passed away, and the other is in terrible condition. Any video of the accident occurring itself?
Zero. No witnesses, no video.
So how do you start to piece together that this is truly a product liability case and not user error?
Well, you basically, there's circumstantial evidence. And on top of it, in this case, which is not unusual, Harold was amnesic to the accident. He didn't have any recall of the accident. So he couldn't contribute his historical accounts, if you will, to what happened moments before, during, or after, because he had no recall. So you have a situation in which you got to put it together through circumstantial evidence. And essentially, it's sort of a diagnosis of exclusion. And then you have to ask, what's the likelihood that the machine had a known defect of a nature that is so exact to what the accident reconstruction experts put together and said, this is how it happens. And in our particular instance, our accident reconstruction expert said that based on the markings on the pavement, based on the imprints on the embankment, where the vehicle landed, the damage to the vehicle, all of the physical evidence, it had to have happened one of two ways. Either it was a brake activation causing a sudden change in direction, or if it was an actual steering input change where the actual operator quickly turned the wheel or turned the handlebars. And he wasn't able to say which one it was. He just said the physical evidence supported one of those two items. So the jury was left with having to decide, was it the defect condition that Harley knew existed, although claimed was not, the vehicle was going too fast to qualify as this particular defect, or was it essentially a suicide mission on the part of Harold, where he was purposely just cut that wheel hard out of the blue for no reason?
So the accident happens in Pennsylvania. I believe on the Pennsylvania-New York border, but in the state of Pennsylvania. And both Pam and Harold are residents of Livingston County, New York. So the case was in Livingston County, New York State Court. Is that correct?
That's correct.
So the PJI that is applicable here is New York PJI, and we're talking about product liability, negligent manufacture, which is 2:125, and negligent design, which is 2:126. That's your primary liability PJI. Is that right?
Right. Well, there's also a failure to warn and warranty defect, well, breach of warranty.
Okay. How do you start to shape this case before you go into jury selection? What starts to become your ethos or the grand theory that you really want to convey to this jury?
Well, in this particular case, it took a lot more thoughtful consideration. And I'll tell you why. Paul and I are both New York City lawyers, and we're in the Finger Lakes, Western New York region, and we are clearly outsiders. We sound different, we look different, we act different. Fortunately for us, Harley had retained their national counsel who goes around the country defending Harley cases, who are also not local players, although they did have a Buffalo firm as their co-counsel. So it was really first had to endear yourselves to your jury pool. And that was essential to overcome that interloper mindset if some of them had that. Now, the thing that you have going for you as a plaintiff in a scenario like this is that you're representing one of their own. So automatically you're going to get some degree of goodwill because even though you're out of town, you're here for a local, and you got to lean into that. And you also have to lean the out of town component of it and demonstrate. And we did, but it was all very sincere, by the way. We rented a farmhouse at an Airbnb because we knew it was going to be a long trial. Didn't stay in a hotel, lived in the community with the people, went shopping in the stores, didn't see the jurors, but saw locals and really got a flavor for it. And we shared that with the jury. We purposely went up a little early just to get a feel for the area and shared that in jury selection. Be like, this is beautiful, waking up these cornfields and this, just clean air, and just really lean into your circumstance and demonstrate appreciation. So that was, but it was all sincere, but that was definitely part of the ethos that we adopted.
I love that. I love that. Telling them straightforward, I'm not from here, but I appreciate what you guys have here. And it's a pleasure for me to represent one of your own. It sounds like really goes a long way in them accepting you and understanding that you're trying to do the right thing for the people.
Conversely, just for the sake of viewers, Harley got up during jury selection and basically leaned into, look, we're as American as apple pie. We're of the earth like you are. They did try and endear themselves to a certain extent. And even at one point said, raise your hand if you think that Harley deserves kudos for a voluntary recall. And all the jurors raised their hands. Now, mind you, they didn't know any details about the case, but it just sounded really good. And so they painted a picture of, hey, this company is good. It's out there to do the right thing. And don't listen to what the plaintiffs are going to say about us.
In terms of your strategy with respect to the facts of the case that you had going in, what was the mentality there, knowing that you were really going to emphasize this recall, this voluntary recall was in fact not as truthful and honest as they made it sound like?
Well, again, you got to know your audience, but you also got to know your facts and which facts jive best with your audience. So we knew that because Harley was relying on its internal engineers as their experts, they didn't go to outside experts. So they didn't have seasoned expert witnesses. They did have one as an accident reconstructionist, but in terms of the inner workings of the machine that we were attacking, the manufacturer defect, the design defect, they used all the internal engineers because they couldn't possibly say to us, we're not giving you this information because it's proprietary in nature. And then they go out and hire some third-party experts. So they had to use their internal people. So we knew right away that they might be smart, but they're not in their element. And you need to factor that into the calculus of how you're going to deal with it. And we drew them out in that respect.
Was the defense here going to try and shift gears and just blame the client and just strictly say this was user error?
Yes. But it had to be user error because it's impossible. And that word was used a lot by the defense. It's impossible for the defect to be a factor at speeds above 40.5. And there was no dispute that both accidents occurred 55 to 60. So they hung their hat on the physical impossibility of the defect happening because the traction control feature wouldn't engage at those speeds.
I'm going to ask the juiciest question of this whole episode. What was the verdict that you got on this case?
The jury came back with $287 million in total between the compensatory and the punitive damages for both cases.
So punitive damages is a part of this case.
Absolutely.
All right. Is punitive damages something that you talk about in jury selection?
Absolutely, yes. But keep in mind, they did try and get out of the case through summary jury. Harley Davidson did try and get the case dismissed through summary judgment motions, including trying to dismiss the punitive damages claim. Fortunately for us, they failed in that, and the court said no, there was enough genuine issues of material fact and dispute on both liability and punitive damages that it can go to the jury. So knowing that, we had the legal right to voir dire the jury on punitive damages aspects of the case.
So you knew going into this, you were going to be asking for a lot of money.
Yes.
give us a little gem, if you would, please, on what it is that you say to the jury in jury selection when it comes to dealing with the idea of awarding money for punitive damages.
Well, you got to demonstrate to the jury what it is and how it works in a way that's accessible. And what I did in this case was I picked a prospective juror and I said, is there an eatery in the area that you like to go to? And, oh yeah. So what's at the tavern? Okay, the tavern. So what do you think the tavern makes a year? Maybe $1 million. Okay, fine. Let's assume the tavern is found responsible and is worthy of being punished, right? They did something wrong and they need to be punished. And you said 1% of the tavern's annual earnings is enough to punish them, send the message, let them fix their problems, let them not repeat their bad behavior. Would that be unreasonable to you? 1%? No, that's not unreasonable. Okay. Does it matter how much it is, what the number is? No, 1%. They can. Nobody's closing their doors. They can continue to serve food and continue to be a go-to spot. They just have to change this one aspect of their bad behavior. And 1% is a reasonable way to do it. Would you be offended by that? No, I wouldn't. Okay, now what if I told you the same exact story, but instead of the local tavern, it's Microsoft, or it's Tesla, or it's Apple, or it's any other massive, huge corporate entity? Same 1%, but it amounts to a different number. Does that offend you? No. Perfect. You're a good juror for our case, because that's what it comes down to. You can't be afraid of the number. You have to realize that the process it's a percentage of their value.
I love that. Starting very small, very local, of course, that doesn't sound unreasonable at all when you put it that way. It's a brilliant, brilliant, brilliant move. And obviously, I got to relate back to the PJI. Punitive damages is PJI 2:278. Check out the language. We'll post it up on the episode here. All right. Any other good bits that you knew you were going to relate back during your case in chief that you said in jury selection to kind of tie all your evidence in together for close?
Sure. We promised the jury. And again, as a lawyer, got to be very careful what you promise, because if you don't deliver and don't deliver clear and clean what you promised, it can come back and bite you in a big way. So promise the jury they'd be outraged at the end of the case. That was the only promise I made. I promise you will be outraged at the end of this case. That was able to build, introducing the theme that we built on throughout the entire thing. So at the very end, they were outraged, because at no time could Harley have defended itself in a reasonable way when they're saying it's not us, it's him, it's the victim. They blame the victim. They ignored their defect. And we were able to prove that the speed limit restriction for the defect was actually not etched in stone. Harley determined in its testing that sometimes the trike thought it was going much slower than it actually was. So this idea that they wouldn't happen over 40.5 might be true, but if the trike thinks it's going 40.5 when it's actually going 60 or 70, then guess what? You got to set up for the defect happening. And that was really a big issue for the jury, as well as the fact that we had the unique circumstance of having 2 accidents with the same trike. That really was our advantage that we played off of from the very beginning.
You have your jury selected and you're going into your opening. Now, there are 2 lawyers, correct? It's you and Paul Edelstein, who represents both plaintiffs against the Harley Davidson attorneys. Is that right?
He represents the operator who survived,
Right.
Harold, and I represent the estate of Pam.
Understood.
So
you guys are giving 2 different openings?
Yes.
And was this a unified trial or bifurcated?
Bifurcated.
All right. So you guys had to get through liability first.
Correct.
Just talking about the liability portion of it, how many experts are we talking about for both sides?
We had 4 experts on liability. They had 4 experts on liability.
And any kind of big aha moment during the liability portion of this case where you really felt a big swing in either one direction or the other?
Yes. One of the things that Harley did was the post-crash photos of the trike showed that there was a bag hanging on the handlebar. And it's sort of a drawstring bag, which was in the trunk of the trike. And obviously, when the thing rolled over in the accident in Pennsylvania, it came out. And somebody, we don't know who, put that bag on the handlebar. But Harley presumed that that bag was on the handlebar the entire time, and therefore it interfered with the steering, thereby making it more likely that this was operator error and the bag interfered with the steering, and that's what caused the accident. It was to me, foolish defense because it was all based on speculation that they couldn't possibly prove. And it seemed very reasonable that because there was no one on the scene, other people before the first responders arrived were on the scene, probably did pick things up off the road and pull them off the road. So nobody knew who put it there. So they basically adopted the presumption that it was on there the whole time. Harold had testified his deposition and at trial is like, I would never ride my trike with a bag on the handlebars. Never would. Never did, never have, and didn't do it this time. So the fact that they were actually embracing such an absurd defense, I think really diluted their credibility in the eyes of the jury. They had their own expert who was very good, but he couldn't get around the fact. And he basically conceded that, yeah, the likelihood of this bag causing this was really low. And that was a big aha moment.
They put all their eggs in their basket. They probably blew up this photo in front of the jury.
Yes.
Right?
Yes.
And that's kind of the moment where you felt the tide shifting.
Well, actually, I will tell you that, and I know this might sound a little pompous, but we never felt like we were behind on any day of trial. Every day on the scorecard, we felt we were ahead. And the aha moment was really just enhancing the already sizable lead that we had in the case, which was proven to be true at the end when we spoke with the jury. And most of them were like, we felt that Harley needed to explain themselves clearly up front in the beginning. They never did, and they never did at the end. So it was sort of like they never were able to change their minds on the thing.
Did the information about the over 90 instances compared to the 5, did that come out in your case in chief, or did you wait for cross-exam?
No, that came out actually, it was teased in our case in chief, and it was exploded on everybody in summation on the liability case. I had prepared slides, various PowerPoint slides, and we had the pieces of information that were out there, and I basically put them together and related them and reconciled them in a visual presentation for the summation. And that's when all the pieces came together. So we basically baited Harley to give us the confirmation on the way things work, and then we put the pieces of the puzzle together in a nice, clear picture at the very end of the liability case.
How long were you on trial for in this case?
A little over 3 weeks.
Do you not become exhausted after about 2 weeks of trial, or even a week and a half? I am coming off of my 4th currently in 30 days, and I'm exhausted. And the last one I did was just a little bit over 2 weeks. I feel like it's not only exhausting for me because your mind is always going, but the jury is exhausted of coming in every day and listening to all this information. And really, I mean, it's really strenuous activity to dial in and focus during the hours of 9:30 and 4:30 during courtroom hours. What do you do to keep yourself sharp?
You, under no circumstances, deprive yourself of sleep. You force yourself to put the work down and sleep. And the idea of an all-nighter makes no sense. It's counterproductive. So if you know you're going into a marathon trial, which I define as 2 weeks or more, you have to force yourself to sleep. And you can get up early, but if you don't get enough sleep, you're doing a disservice to your client.
I feel like that's easier said than done, especially for a young guy like me. My brain just doesn't stop. You're thinking about the next witness, about the next day, about what just happened the day before. So I think that's really good advice for everyone to hear is don't discount how important sleep is during your trial. Waking up refreshed and with a clear mind goes a long way. So I appreciate you.
But it actually it's even more important. It's medicine, it's therapy, whatever you want to call it. But if you're not paying attention what's going on in the courtroom because you're too glassy and tired, then you can't respond in kind. So all that preparation that you did getting ready for the case is basically wasted because you can't react on your feet because you didn't process the information that happened in real time right in front of you.
So when it came to the verdict on liability, how did the jury find?
They found 100% against Harley Davidson, 0% against Harold, the operator. And that actually was probably the most emotional part of the entire case, was when both Harold and Pam's family realized that the jury found zero responsibility for the happening of this accident on Harold. And Harley had basically been pinning this accident on him for over 4 years. Very convincingly, by the way, in terms of their comments and the way they presented their case. And it was all operator error. That verdict really liberated Harold from the prison they put him in, emotional prison, of thinking that even if it was their fault, he had something to do with it. He might have been able to do something different. And the jury cut those chains off him.
That's incredible. It's incredible when you're there in the courtroom and when you see the emotion, when you feel the emotion. What we do, it can't be described in words. When you get a right and just verdict, the relief that these people feel is, I would say, worth more than the monetary value of any verdict.
It sounds good to say that, but it is actually very true. That is, for me, way more valuable. That's the thing that endures. Sleeplessness is a form of torture. Now imagine if you doled it out in small pieces over the course of a person's lifetime. That's torture. To release them from that kind of emotional, mental anguish is liberating on a level that money can't give you.
Yeah, incredible result on liability. I want to change gears and move into the damages portion because you did something here with Pam's case that I think is vital for every single attorney to hear. So we have an injury of death, but you included, well, give us the details as to exactly what the injury was to Pam that you had claimed in the damages portion of the trial.
Well, being the fact that the accident was not witnessed and everything was circumstantial in nature, and we know that at no time was anyone able to offer evidence to support that she was alive anytime post contact with the ground. It was all speculation. So realizing that I was limited and realizing that essentially, at most, conservatively talking, in the light most favorable of the plaintiff, you had maybe 5 seconds at most between the trike first destabilizing and Pam coming to rest on the ground. So 5 seconds is not a long time, and it comes down to seeking compensation. But I did realize after, I've been doing this over 30 years, that 5 seconds may not be a real 5 seconds under such heightened emotional, stressful circumstances for an individual. So I reached out to a neuroscientist, clinical psychologist by the name of Heather Berlin, and here in Manhattan. And she had never testified before. And I had said, look, let me present you the facts of the case and tell me what you think. And when she heard that Pam had been the victim of this kind of an accident previously, that she had expressed anxiety and fear of getting back on the trike, but that she ultimately decided to get back on because Harold was her boyfriend and they were trying to move on with their lives, but that she always was uneasy, that she had a hyper sensitivity and therefore she was hyper vigilant about anything. So think of it like if someone's on a plane and there's turbulence, you might be like, oh my God, we're going down. There's a sudden change in everything that goes on in your body. And there's actually chemical changes that happen as well in those heightened states of fear and anxiety. So she explained that given the time frame, 3 to 5 seconds, that's not a real 3 to 5 seconds for her, the person experiencing this heightened sense of fear. And the law does allow for something called fear of impending death or fear of impending doom. She was able to really describe and explain both physiologically and pathophysiologically in terms of what happens in the brain, what goes on, including the alteration of time perception. So you've heard the expression, I was so scared my life flashed before my eyes. That's a true phenomena in which, in a matter of seconds, a person can process hours of information, the equivalent of hours of information in real time, in a matter of split seconds. So she was able to use the fact patterns that we gave and say, in all likelihood, she experienced these various emotional doubts and questions and fears. Oh my God, who's going to take care of my kid? And who's going to look after this? And all of these things that happened in her brain, which would take a normal person hours to experience, happened for her in a matter of seconds. So that was really able to paint a great picture of the alteration of time perception for someone in a heightened state of fear.
To take what most attorneys would say, I got 5 seconds here, and to turn it around, to retain a neuroscientist to talk about, ultimately, we're going to call it pre-impact terror, and do what you did is incredible. When she did testify, the neuroscientist, you mentioned briefly time slows down when you're in that heightened state of mania. So what did she testify to? What are those 5 seconds equivalent to when you're in that state of mind?
She said, if you were to measure it in real time, as we perceive time, you're looking anywhere from minutes to hours. And it all depends on the individual. But because of her hypersensitivity to this accident having happened before, it was closer to the hours than the minutes. So if somebody's completely unexpecting of something, they're not processing it quickly enough. But if they live in fear of it, then they're going to process it more quickly. So she had a greater understanding of how dire the situation was much sooner, even though we're measuring this in like milliseconds. And therefore, the amount of stress that she experienced, the amount of pain and suffering, if you will, mental, emotional pain and suffering, actually lasted way longer because she was a second time around sudden departure from the roadway on this trike.
So that is PGI 2:320, which is the wrongful death and conscious pain and suffering. And obviously, this pre-impact terror is conscious pain and suffering. So did you touch on that in jury selection? Did you have any good moments there when you spoke about this kind of concept?
Yes. In fact, one of the panelists who we did not choose on the jury was a hospice nurse. And I asked, are you familiar, are you open to the concept of pre-impact terror, fear of impending doom? And this nurse in front of the whole panel described that, yes, it's a real thing. I've seen it happen before. I've, do hospice stuff. And so she really sort of endorsed, to a certain extent, the concept, although I couldn't get into great detail and, chose not to select her for other reasons. But that didn't hurt in sensitizing the jury that, oh, this is a real thing. But I believe that Dr. Berlin was so compelling. In fact, even the judge said, by far the most compelling witness in the whole case. Not the smartest necessarily, because there were very smart people and engineers talking, but in terms of the information that was learned by the jurors and the audience, that was by far the most unique and unexpected, if you will, of the whole trial. And my suspicion was that if I could convince a jury that seconds really was like hours, that I could justify getting a big number and keeping that big number on appeal. So I did some research in New York State and saw what the biggest sustained pre-impact terror verdict was, and it came from the crane case, the crane collapse case in Manhattan, East 91st Street. And that was 2.5 million for about 20 minutes of pre-impact terror, meaning from the time of injury up until the time they died. And or fear of impending doom, I should say. And so wasn't looking to break any records, just looking to match it.
Get a sustainable verdict. Any position from the defense on the damages portion of the case?
Even to this day, I'm still bewildered by it. Harley Davidson deferred its opening statement, which I don't even know what that means. You can't defer it. You either do it or you don't. So they
Waived
basically
it.
they bailed it. They waived it. And then of the 14 damages witnesses that were put on between my case and Paul's case, they asked about 7 questions of one orthopedic surgeon on Paul's case. And that's it. They waived cross-examination of all the other damages witnesses.
They waived their opening on damages. Was there anything else that they did during the damages portion to try and limit the punitive damages aspect of the case?
Yes, actually, there's something they tried, but fortunately for us, it didn't succeed. Harley showed up with a case from the 1980s from the Ninth Circuit Federal Court that said that when you're being sued for punitive damages and defending yourself, you can bring in proof of changes in your practices for the jury to consider as a way of downgrading the extent of punitive damages or diluting the extent of punitive damages, and say, look, we've taken it upon ourselves to self-police, therefore don't hit us as hard. And that was their intention. So they wanted to bring some bigwig vice president out of the boardroom to Geneseo, New York, and put him on the stand so he could tell the jury, look, we've heard your verdict in the past 4 days, we're changing our culture moving forward and all that stuff. We obviously objected, saying we're looking at this case, and this case spoke to years between being sued and the verdict. The company had changed its evil ways, and that the court allowed to come in. Not 4 days between having a jury tell the world that you did wrong and you now saying we've learned our lesson thanks to your verdict. So fortunately for us, the judge said, you could put this guy on the stand, but I'm not letting you have him talk about how the culture is going to change as a result of this liability verdict from 4 days ago.
So they tucked their tail between their legs. And when it came to closing, did they suggest any kind of numbers?
Yes. In closing, they did suggest that essentially a fraction of what we had sought was reasonable, if anything was reasonable at all. As sometimes defendants will do, is they'll say nothing is worthy, that we didn't do anything wrong, therefore don't award anything. But if you feel anything is justified, then, it was a fraction of it. It was not, it didn't even amount to $1 million that they had suggested was a reasonable number if the jury felt something was worthy of being awarded.
What was the pretrial offer before this trial went?
The pretrial offer during a mediation was $275,000.
Tell me again, what was the total verdict?
$287 million.
Woo-wee! That's big justice on 3 wheels.
Yeah. Yes, it is.
So how do you unwind after that kind of a $287 million verdict? How do you unwind?
Well, again, I guess only for me, I try not to do anything that's too extreme, beginning, middle, or end. I try and live somewhat of an even-keeled life. So to unwind, I basically take a few days off, just revel in the accomplishment of all the work that paid off. And then I get back to work. There is sort of a depression that can set in if you let it. And I've had that experience before, where you just had so much action. It's on such a level that you can't really describe unless you live it. And then all of a sudden you go back to your, I'm going to draft some bill of particulars next on a case. And that's going to be rivaling that type of euphoric, that inner chi, that sort of energy. It doesn't, but you have to accept it for what it is. This is a cycle, with every ending comes a new beginning. And, but you do take with it a certain amount of confidence to know that when I am drafting that bill of particulars on another case, I'm going to do a damn good job, and I'm going to make sure that I'm going to see this case through to the end like I did the one I just did. So, I try and have somewhat of an even keel about it all.
Thank you for being here. Congratulations on an incredible win that actually made a difference. I think the key that we are going to continue hearing in these episodes is that these wins aren't just wins for our clients. They are wins for everybody. They are wins for the people riding Harley Davidson. In your case, we're hoping that this kind of punitive damage gets them to truly make different decisions in the future. And it really helps the personal injury attorneys listening and realizing that it's not just about what you say and do at trial, it's everything that comes beforehand. All right, that's it for this episode of Trial Bible. And we know that even if justice is blind, it always hears a good argument loud and clear. Thanks, Dan.
My pleasure. Thank you.
That's a wrap for this episode of the Trial Bible. We hope you've gained some valuable insights. Don't forget to subscribe, rate, and review so you never miss an episode packed with winning tactics and expert advice. Thanks for tuning in.